All rise for the court. In the case of Donald J. Trump versus the Hawaii, presented in September 2017, mandated effectively in January 2018, and revoked in May 2018, case number 17965.
Attorney Noel Francisco, representing the President of the United States, Donald J. Trump.
Defense Sonia Sotomayor, arguing case number 17965.
Mr. Chief Justice, and may it please the court, after a worldwide multi-agency review, the President's acting Homeland Security recommended that he adopt any restrictions on countries that fail to provide the minimum baseline of information needed to vet their nationals. The proclamation adopts those recommendations. It omits the vast majority of the world, including the vast majority of the Muslim world. Because they meet the baseline, it now applies to only 7 countries that fall behind the baseline and had other problems that exerts diplomatic pressure on those countries to provide the needed information, and to protect the country until they do. The proclamation reflects a foreign policy and national security judgment that falls well within the President's power under 1182F, and has been successful, which is why the country of Chad was recently dropped off the list.
As with EO 13769 and EO 13780, was immediately criticized and was legally challenged in several cases. Of note was a challenge from the state of Hawaii, which formed the basis of the Supreme Court case. Hawaii brought a civil action challenging the executive order on March 7th, asking for declaratory judgment and injunction halting the order.
The Department of Homeland Security, in consultation with the State Department of Intelligence agencies, developed an information and risk assessment baseline. DHS then collected the evaluated data for all foreign governments, identifying those having deficient information, sharing practices, and presented national security concerns, as well as other countries at risk failing of meeting the baseline.
The state of Hawaii moved for leave to file the amendment complaint pertaining the Executive Order 13780, Doug Chin, under the pretense of the national security. It still targets immigrants and refugees. It leaves the door open for even further restrictions. The amended complaint lists of 8 specific causes. First, the violation of the First Amendment establishes clause claiming the travel ban targets Muslims. Second, violation of the Fifth Amendment Equal Protection Clause. Third, the violation of the Fifth Amendment Substantive Due Process Clause. Violation of the Fifth Amendment Procedural Due Process. Fifth, violation of the Immigration and Nationality Act 8. Sixth, violation of the Religious Freedom Restoration Act 42. 7, the substantive violation of the Administrative Procedure Act. 8, procedural violation of the Administrative Procedure Act 5.
We believe after a 50-day period during which the State Department made diplomatic efforts to encourage foreign governments to improve their practices, the Acting Secretary of Homeland Security concluded that 8 countries, Chad, Iran, Iraq, Libya, North Korea, Syria, Venezuela, and Yemen, will be refused entry into the United States.
On March 15, 2017, U.S. District Judge Derek Watson issued a temporary restraining order preventing Sections 2 and 6 Executive Order 13780 from going into effect. In his order, Judge Watson ruled that the state of Hawaii showed a strong likelihood of success on their Establishment Clause claim in asserting the Executive Order 13780 was in fact a Muslim ban. Judge Watson started in his ruling, when considered alongside the constitutional injuries and harms discussed above, and the questionable evidence supporting the government's national security motivations, the balance of equalities and public interest justifies granting the plaintiffs.
She recommended entry restrictions for certain nationals from all these countries but Iraq, which had a close cooperative relationship with the U.S. She also recommended including Somalia, which met the information sharing component of the baseline standards, but had other special risk factors, such as a significant terrorist presence. After consulting with multiple cabinet members, the President adopted the recommendations and issued the proclamation. DHS recommended entry restrictions for certain nationals from all those countries but Iraq, which had a close cooperative relationship with the U.S. They also recommended including Somalia, which met the information sharing components of the baseline standards, but had special risk factors, such as a significant terrorist presence. After consulting the multiple cabinet members, the President adopted the recommendations and issued the proclamation.
Nationwide relief is inappropriate in light of the likelihood of success on the Establishment Clause claim. He also stated concerning the order and neutrality of religion that the government's position that courts may not look behind the exercise and executive discretion and must only review the text of the order was rejected as being legally incorrect, and that it is discriminatory purpose that matters, no matter how infants and affection equally flawed is notation that the executive order cannot be found to have targeted Islam because it applies to all individuals. In the 6 referent countries, it is undisputed, using the primary source upon which the government itself relies, that these 6 countries have overwhelming Muslim population that ranges from 90.7% and to 99.8%.
For all of the reasons stated before, we believe the travel ban was made purely for hateful reasons. This ban should have never been brought up, and we fully disagree with it.